All right, time now is 2:42. May we request everyone to please come back and settle down so that we can proceed to our next talk. So yeah, we'll just wait for people to return to their seats and then we will resume immediately. Okay, let's resume. Our next speaker is attorney Darwin Angeles. He will deliver a talk entitled Ethical and Legal Considerations of AI Creations on Philippine Copyright Landscape. Attorney Angeles is a partner at Molo, Sia, D. Tuazon, and Coloma Law Offices, or Mosvelt Law, where he leads the Intellectual Property Department. He has extensive experience in patent prosecution for computer-implemented technologies, commercialization of IP assets, and IP rights enforcement. In particular, he has registered multiple patents involving blockchain, data science, and AI technologies. He has litigated cases invalidating evergreen patents and defended companies from multi-million-dollar patent infringement suits. He has considerable experience in IP enforcement actions in partnership with law enforcement agencies. Attorney Angeles has also appeared before the Philippine Supreme Court in high-profile constitutional cases and represented notable figures in the legal community. He has also been cited multiple times as rising star and next-generation lawyer by Legal 500 Asia Pacific. Attorney Angeles has a Master of Laws degree from Queen Mary University of London, where he focused his research on the intersection of human rights, technology law, artificial intelligence, data privacy, and intellectual property laws across the UK, US, and EU. He obtained his Juris Doctor from the University of the Philippines and holds a degree in chemistry from Ateneo de Manila University. Everyone, let's give a warm welcome to Attorney Darwin Angeles.
Thank you, Chris, for that very kind introduction. Good afternoon, everyone. I hope everyone's doing well. And thank you, Professor Jello, for that very interesting introduction on the world of artificial intelligence. So, well, I think Professor Jello spent a good part of the hour trying to demystify AI. So I hope you will pardon me by me trying to complicate things a little bit for the next hour. But, you know, I'll be raising issues, but I will also try to walk you through possible solutions for them. Okay? So this talk that I've given, I'm very fortunate to be speaking before you as, on behalf of the Philippine Bar Association on this very important topic of AI. I've given this talk in various versions, one before the Intellectual Property Office, another time before the Ateneo Intellectual Property Organization, and then another version before the Commission on Elections. And briefly, well, we'll be talking about, well, what is the state of the law and regulations concerning AI. So Professor Jello has given a very concise overview of the technology and capability of AI, its potential, both boon and dangers. So what has the law done to try to keep track? What's the relationship between copyright and AI? I use copyright law as a lens because recent developments show that copyright is the field of law that most engages AI, ironically. And then, what are the legal and ethical considerations arising from that connections? And what's the relation of AI in the Philippines, especially with respect to the Philippine copyright landscape? Okay. Before I begin, I'd like to call everyone's attention to a few contemporary developments here in our country. So we recently had the State of the Nation address by the President, and AI was among his key policy directions in his last SONA. It echoes what he said last March 20th, making AI a cornerstone of his administration. And in line with this, several line agencies of the government, such as the Department of Trade and Industry, earlier this month rolled out concrete plans, at least to determine where the government will focus on AI development. So you have the DTI. The NEDA also launched their own plan, and they have very rosy outlooks for favorable use cases for AI use in the Philippines. Okay. Just last week, the Commission on Elections conducted a study. They invited the various academics, practitioners, to tackle the use of AI in elections, deepfakes, and what frameworks are available in regulating the same, and with the view of coming out with comprehensive rules that will govern the 2025 elections. Okay? And then this one, very interesting, statistics from a study published by Microsoft showed that AI use in the Philippines is actually more widespread than we think. Our workforce, in one way or another, is actually using AI in some level. And there seems to be this impression that the Philippines is a laggard with respect to AI. The numbers would say otherwise, and in fact, we are a pace, or in fact, leading in the world in terms of AI use. Okay. So this brings us to what has the law done with respect to AI? So in his talk earlier, Professor Jello mentioned the European Union's AI Act. Now, this one is a groundbreaking piece of legislation, which is the product of years of debates, policy memoranda, lobbying by interest groups and technology companies in the European Union, because this piece of legislation promises to build on the successes or perceived successes of the European Union with respect to the GDPR, which is the precursor of our Data Privacy Act. So the goal of the European Union is to achieve what they termed a so-called Brussels effect. That is, the regulations that they come up with become the gold standard that is followed around the world with respect to AI. And that's their goal for the AI Act. Now, because of the complication of the AI Act, I think Professor Jello discussed an annex of the AI Act. When you look at the text of this law spans at least 500 pages. So it's you can write an entire dissertation on just a chapter of this AI Act. But let me try to run through some key provisions. The good thing with the amount of time that they spent with this law is that it's very well indexed. You have a good idea of what it tries to cover. So you have, you have the definition of the AI Act. Professor Jello mentioned that earlier. Okay, and then one of the key features is that they classify different types of AI. So they have identified certain prohibited uses. So social scoring systems for one, AI that is primarily used for deception and manipulation, as opposed to an AI system that is capable of doing other permissive or beneficial uses. So this targets those kinds of AI that are very, very harmful. Um, there is there is a debate also ongoing in Geneva before the Red Cross about whether we should enable smart weapons with AI with a kill switch. Sorry, not a kill switch, a kill function. A self-autonomous AI that can take a human life. Triggering, and from the lens of human rights, can you give a robot the power to violate one of the laws of Isaac Asimov, which is that a robot should do no harm? So I think under the current framework of the European Union, that's classified as prohibited. You also have high-risk AI. So it's subject to stringent regulations. So an overview would be, it would be registered, it would be monitored. There are post-market monitoring, post-market surveillance and monitoring mechanisms established by the AI Act, which I'll discuss briefly. But let me just go through the other remaining classifications. You have limited risk AI. So these are would have been classified as high risk, but because the level of threat associated with these AI systems is low, they're subjected to less stringent regulations. So it's a bit relaxed. And then you have minimal risk AIs. So these are AIs that can be used for general purpose, like you have your navigation systems, recommendation, spam filters, so to speak, etc. Okay. So other standards provided for under the AA Act, well, they actually have baseline standards, and then with respect to certain categories, they've tasked the AI office, so they don't even have the entire framework figured out yet. They will come out with certain standards that will be rolled out and applied to high-risk AI within 12 months. So that's why under the AA Act, certain systems that may be classified as high risk can temporarily comply with the requirements of the AI Act by undertaking what they call a code of conduct. So, so that if they assume voluntarily, the AI software operator assumes voluntarily a set of obligations, and that's deemed as compliance until the AI authorities in the EU codify what the hard regulations are, and everyone is bound to comply with it. And then in respect to that, you have the EU AI office. So the way they've envisioned to regulate AI in the EU is that there is a central AI office, probably in Belgium, where the HQ of the EU is located in Brussels. And then there are national monitoring AI agencies that will implement the terms of the AI Act according to the national law of every state in the European Union. And the obligations of enforcing the standards of each AI Act is, in its essence, it's akin to devolution in local governments. It will be implemented on a per-state basis. Okay. And then I adverted to market and monitoring mechanisms. So there's a post-market monitoring. It's an obligation imposed on the service providers. They are obligated to monitor how their systems are being used. Because when you have an AI system, it's governed by terms of service or terms of use. So you remember that annoying EULA that you always have to click I agree before you access a new program, a word processing software, or even a new website. So that's essentially a contract between the user, you, and the operator of the software that you will only use that website, that software for specific purposes. And if you use it for other purposes that are not contemplated by that license agreement, you are essentially violating the license, and therefore your act is unlawful. And on that basis, the software provider can claim that they have a defense, or they're covered because the software is being used illegally by the user, and therefore liability is theoretically imposed on the user. So the goal of market monitoring is to ensure that the providers of AI be the ones to police. So they make sure that everyone is adhering to the terms of service. And then you have the market surveillance, that's the state side. So it's another level of oversight to double check that are the users doing what they're supposed to do, or are the service providers living up to the standards that they claim to be reporting? Because there is also a reportorial mechanism under the AI Act. Now, well, that's a quick overview of the AI Act. There's, of course, there's a lot of details to it, but I hope that was helpful. Let's go across the Atlantic. So you might be wondering, what is the United States doing? Because they're quite the leader in AI. If you think about it, almost all of the big AI companies are based in the US. You have Meta, you have Amazon, you have Google, you have Microsoft. Okay, so the US takes a different approach, understandably. For them, AI is a tool for national development. And strategically, they want to be the global leader in AI in terms of technology, in terms of use. They want to give their industries, their government, their security forces an edge with respect to AI in relation to the rest of the world, and maintain that edge. So most of their policies are actually geared toward that goal. So they don't have an AI Act similar to the EU because, to their mind, if they impose these kinds of regulations to Silicon Valley, it would be a dampener to innovation because it would devote substantial resources from these private companies to complying with the stringent requirements being required of the AI Act. So, and then there are two laws. They're not exactly tech laws, but they have a direct bearing on artificial intelligence. One is the First Amendment. Why? Because content generated by AI can qualify as a form of expression and therefore constitutionally protected. Now, depending on the context, the level of First Amendment protection may vary because if it's civil or political speech, we know that their level of constitutional protection is higher, almost to the point of inviolability. But if it's commercial speech, then there are some concessions, but it's still constitutionally protected. And then you have Section 30 of the Communications Decency Act. Some of the people here in the room may be familiar with this law because this law has been in effect in the United States for a long time. It was enacted in 1996 during the advent of the internet, okay? It was put in place to encourage the then bludgeoning internet industry to accept a lot of investments, make a lot of money. How does it work? Essentially, if you are a platform, you are a web service provider, you are operator of a website, if somebody uses your website and violates your terms of service and you host, say, something that is that harms another person, you host a porn video or a defamatory image, the fact of you providing the service of hosting and making that image or video available is not actionable as a matter of law. That's what Section 230 does. Why? Because the true party at fault there is the person who caused the uploading of the injurious video or content, or that's the way the theory goes. So what in effect this does is it prevents gatekeeper liability. Now we refer to these companies, the websites, the platforms, as gatekeepers because we access their service through their software that they have on offer. And because of Section 230, they can claim that if you have a problem, for example, somebody posts a deepfake video about you online, and if you have a problem with it, they can't take it down right away. You have to look for the person who uploaded it and get a court order against that person and make that person liable. Until then, they're not legally obligated to do anything. Or at least that's how Section 230 is supposed to operate. In other jurisdictions, though, there are laws providing for gatekeeper liability because they don't have a provision like Section 230 to provide such a shield, okay? So I've also mentioned the White House Executive Order. It also contains a definition of AI, so I quote it here to give an illustration of how, well, it contains a looser definition of AI in my opinion, but no need to delve into that. Okay. And some policy considerations. So you can see here some key points, as I mentioned earlier, what the US wants to focus on with respect to AI. Now, I highlight this because we'll look at China's policy in a bit. Oops. But, sorry. Okay, so there are 8 points. Safety and security of AI. Okay, right. Now, on a specific use case, we talked about deepfakes earlier. On the federal level, the US does not have a specific statute addressing AI, but that does not mean that states can't do anything about it. So on a narrow level, at the state level, at the very least, some states have enacted certain laws prohibiting use of deepfakes in electoral activities. So for example, in view of the 2024 election that they will be having later in November, 6 states have at least passed laws that criminalize or regulate deepfakes or confer some remedy to candidates aggrieved by deepfakes. So at least they have some form of remedy against them. Okay. So what about China? Okay, so I always include China in the conversation because in the global conversation, China also wants to be a dominant force with respect to AI. Actually, there are other players. You also have Russia, but they've been a bit quiet since the war in Ukraine, and you also have India. But they don't have much policies yet on AI, at least to my knowledge. But this one, the one issued by China, was issued just last year in August 15, 2023. Okay. And it has some policies that you can cross-reference with the U.S. White House executive order. One thing I want to highlight about this is that China sees AI as a tool for furthering the state's agenda, which is prosperity for China and furthering their international agenda around the world. So they have a policy allowing for takedown if they think that the content is not in accord with state socialist policy or undermines national security or tarnishes the image of the Communist Party of China, among other things. And then it also imposes obligations on AI service providers, so they don't have a Section 230 shield, unlike that in the United States. Okay. Anyway, so this is a part about which we can skip because Professor Jello was kind enough to give a very detailed discussion on how AI works. So now let's go to copyright. Okay. So I'm sure everyone is very curious about how the creative industry is being revolutionized by generative AI. And yes, as shown by Professor Jello earlier, its potential is indeed immense. Take this, for example. Is this the best piece of art that you've seen? I'm not sure if everyone here is an art connoisseur. I don't consider myself an art lover myself, but would I buy this piece of art? Probably not. It doesn't appeal to my aesthetic interest. But somebody in the world bought this, and believe it or not, they bought this painting for almost $500,000. It was sold in 2018 in auction in Christie's for $432,500. And then if you look at the, this image was created by AI. So it was part of a series of portraits. Essentially, the AI system was fed 18th century portraits, and it was asked to create family portraits of a fictitious Bellamy family. And this was one of the last paintings portraying a member of said Bellamy family. But so if you look at the lower right corner, there is a mathematical function there, and that's the supposed AI signature, which is part of the AI's code. How cute. Yeah. So with respect to copyright though, so even with the art selling for almost $500,000, the one created by AI, can there be any rights with respect to AI-generated work? Now, there are two schools of thought regarding this. The first one is the US school of thought, the one espoused by the US Copyright Office. So you have the position that they put out last year, March 2023. There's guidance provided by the US Copyright Office. And in brief, it just focuses on the human element of copyright in the the creative part of human contribution with respect to copyrighted work. Okay, so this is if you remember in your copyright class, there is a doctrine that to be eligible for copyright, a work must have a modicum of creativity. There's this ruling called Feist versus Rural Telephone Company, which involved this rather archaic question: can a telephone directory be entitled to copyright protection? And there, the Supreme Court of the United States said no, because a telephone directory is just a compilation of names and phone numbers. There is no creative element to it. So to be eligible for copyright, that case brought about the concept of originality, which means that there must be a modicum of creativity. Now, the US Copyright Office has extended this further and said that creativity means that there must be a human element, that the creative mind involved is a human being. And then this concept, right after, was tested in court. Dr. Thaler he's a scientist, also one would say a tech advocate or activist. So he's known for filing cases all over the world, testing the fringes of intellectual property law with respect to AI. So before this, he's actually filed cases in various patent offices trying to patent inventions where the named inventor is not a person, but an AI system. So he has other AI systems. So in this one, he has a creativity machine, what he calls a creativity machine, and he asked the creativity machine to create that image on the lower right. And he tried to apply for copyright. By then, the US Copyright Office had already issued their guidance, and therefore, they ruled that the image did not qualify for copyright. And he took the US Copyright Office to court. Okay. So the US District Court, when they were confronted with the issue, they said no. They sided with the US Copyright Office. So the court there did a study on the history of copyright, and the essence of the ruling is here. It is that understanding that human creativity is the sine qua non at the core end of copyrightability. So please remember that, because we'll be coming to that later when we discuss the other school of thought. Okay. So interestingly too, the district court was also guided by other precedents in the US system. Particularly, there are two rulings in the Federal Court of Appeals which involved claims of copyright by non-human entities. In particular, you have the case of Orantia Foundation versus Kristen Maera. So this case involved a claim of copyright to a work of what the applicant called were angels. So according to her, she had a vision, she recorded words of scripture that were narrated to her by angels, but for some reason, the words of the angels needed copyright protection. So when they were submitted for copyright, the Copyright Office rejected. And the court agreed with the Copyright Office because they said that words of celestial beings are not copyrightable. Meaning, I guess if they were truly celestial, it should be available for everyone. And then you have the famous case of this monkey, Naruto. My friends call him Naruto with an accent. But it essentially involved that famous monkey who found a camera in the middle of a rainforest and took very, very nice selfies of himself, including this. And the issue was, can the monkey have copyright? And the Federal Court of Appeals also said, no, it can't have copyright. So finding and using principle of stare decisis, law of precedent, court said, definitely the creativity machine cannot claim authorship. Okay. Did it stop there? Well, there have been other people who tried claiming copyright using AI works. So how about if the author is not exclusively an AI system, but it's a human being being assisted by an AI system? So this one was just decided last year, December, involved this very interesting piece of work. So you must be familiar with the painting Starry Night by Van Gogh. And this guy, Mr. Sani, took a picture of a sunset, and he asked, I believe Midjourney, the AI system, to create the image that you're seeing here. Okay? And then he applied for copyright, claiming that it was a creative work. Okay. Now, the Copyright Office in December 2023 said no, citing um, the, the directive that it issued, as well as pointing out that the work fails to point out, or at least the application for copyright fails to point out what part of the resulting work product bears the human creativity. Because the theory of Mr. Sani is that I participated, there's a human who was the moving consideration behind this work product, must be copyrightable, even according to the originality rule. But the thing is, you look at the two elements, and they were combined with for the work product, you cannot identify which part here was the AI's contribution. And then there's another part of AI also that must be mentioned, which is the black box dilemma, okay? So in machine learning and even deep learning, one big problem of AI, and this also applies to decision-making AI, is that not even the makers of AI know how the AI arrived at its decision, especially those that are involving artificial neural networks. Because in deep learning that use ANNs, the AI essentially teaches itself, and it has it learns certain factors, assigns weights to certain factors, and based on the weights that it does, and through repeated iterations of processes, comes to a decision. Now, even the scientists behind the AI system can't find out what are the exact number of weights that the AI used to arrive at a certain decision. So that's what we call as a black box dilemma. Of course, there are AI systems that have been designed to have some measure of explainability. That is, the decision will, or the AI can be made to explain what were its key considerations in arriving at the decision. So that's what we call explainable AI. But as it stands, there are a lot of AI systems that are, in a way, black boxes, because not even the people who made them know how they tick. And as applied here, because the work is inseparable in essence, the Copyright Office was at a quandary. Which one is the human element? Which one is the AI element? This one is another interesting example, because what if, can I claim that I did the creative work through the prompts that I give to artificial intelligence? That was what Professor Jello said earlier. The inputs you give to AI are the prompts. So there's a mid-journey AI system, and it created this image. And then the artist improved it using Photoshop. So he used an AI system to make it high-res, and then he edited the high-res image using Photoshop to arrive at this work. So if you notice, there are a lot of more details in the background. But in essence, 80–70% of the resulting image is still the original image. Now, the controversy here is that the author of this work submitted it for copyright with the Copyright Office, but he failed to disclose that the work actually was submitted to an AI competition and won. So there was a bit of fame regarding it as a known piece of AI created work, and it was not disclosed in the copyright application. So when the Copyright Office required Mr. Allen to explain how this image was created, and he made a material misrepresentation saying that he did not use AI, it was taken against him. But in any case, the ultimate criterion also of the Copyright Office, so they rejected the application for copyright protection, citing the same ground that the image resulting from the prompts was inseparable from the original AI. Now, the work was also, now what about the text prompt? So this is what the Copyright Office had to say about it. His text prompts, despite the volume, are not acts of human creation because the traditional elements of authorship are determined and executed by the technology, not the human user. Okay? So here, you can see that most of the image really was part of the original, which was created solely by AI. So the copyright said that the human elements are just de minimis and therefore do not qualify for copyrightability. Okay, now what about this image? Well, these set of images. So you might be wondering, why am I showing a bunch of images? No, these are not pictures of my girlfriend. These are pictures generated by AI. So this is a case in China decided just last year involving Li versus Yu. I understand that Li is a man who wanted to create the ultimate girl, describing this phrase, tenderness sent by the spring breeze. So he wanted, an image of a girl in spring with a bit of wind fluttering in her hair, accentuated by her clothing. So you can see that the progression of the images shows certain attention to detail. The eyes, the hairstyle, the braids, the lack thereof, even the hair, and the clothing. Okay, so he did a bunch of prompts to I believe it was Stability AI who was used here. Yes, Stable Diffusion AI. So and he uploaded the resulting image in social media. And then later on, he discovered that a different person used this image to illustrate another poem called Love in March Amongst Peach Blossoms, and it was uploaded in another website without Mr. Lee's consent. And it was clear in the facts of the case, based on the unofficial translation I got, that at least Mr. Lee's act of creation predated the publication of Mr. Liu. And based on the pleadings also, it was not disputed by Liu that Mr. Lee was the one who originally created the work. So essentially, the case involved infringement, and Mr. Lee sought at least 5,000 yuan in damages. The defense, however, of the AI was not a key consideration in the case. The defense was that it was good faith. But as we know, in Philippine copyright law at least, good faith is not a defense in copyright infringement. So how does AI figure into this? Well, if the American rule would be followed, then Mr. Lee will have no cause of action because there's no copyright to enforce. But here, the court said that Mr. Lee can enforce his copyright, thereby recognizing that copyright subsisted in the image. So part of the evidence for Mr. Lee was that he was asked to reproduce the exact text prompts as to how he arrived at the image. And based on the decision of the court, he was able to reproduce the exact same image using his text prompts. At least that's what the case says. But what's interesting here is the rationale of the court, the ratio decidendi, which is a marked departure from the US rule. How did the court arrive at saying that the AI-generated image is protected to copyright? So the court essentially said AI is a tool. So we go back to Professor Jello's starting point, which I also emphasize here. AI is a tool, okay? And then similar to how copyright law was also developed through the centuries, there was a time when even photographs did not enjoy copyright protection because it was deemed that the act of photography did not employ creative means. So there was no creativity involved. Courts essentially said that's exactly what's going on with AI. Disputed image was independently completed by the plaintiff and reflects the plaintiff's personal expression. Okay, so the court said that when we look at technology, technology essentially involves expanding the limits of the human body. In the same way that cameras allowed us to capture a moment in time, video cameras allowed us to capture moving video, AI is allowing us to, at least communicate to a machine what we have in our head and enable the machine to create something out of existence. Or at least that's what the court is essentially saying. So it likens AI to a camera, and then that as technology develops and becomes more intelligent, less human input is required. But the mere fact that less human input is required does not diminish the creative process involved, according to the court. All right? So they also likens the work of AI to a person who commissions a painting. In scenarios where someone commissions a painting, the client will set some certain requirements. So it's likening the requirements to the prompts. And the commissioned artist will create the artwork by drawing the lines and filling colors based on these requirements. The difference being, instead of you have an artist, you have AI who's actually doing the painting here, okay? And the commission has their own will, integrates their choices and judgments in the painting. By contrast, AI models do not possess free will and are not legal entities. But for the court, this circumstance is not a problem because when people use AI models, the issue of determining who is the creators between the two entities does not arise. Well, the court was able to say this here because, at the very least, the license involved in the AI system, the AI operator does not make any claim of rights whatsoever to the work product that users make on the system. So it's really use our tool. The resulting work product is yours, subject to, of course, compliance with the stable AI's terms of service. So in essence, to cap, it is still human beings using tools to create where the intellectual input in the creative process from the human. And encouraging creation is the purpose of the copyright system. So the court is saying that if we refuse to accord protection to AI-generated works, then it's actually belying the very purpose of the copyright system, okay? And yeah, so while they also said that the fact that there is an AI is not a living person, they likened it to a corporation. So the court said, well, the corporations can have copyright. Why can't an AI system intervene in the creation process, thereby giving rise to a copyright? It's the same tool analogy, okay? So, and I think the court really was convinced, or it was inspired, I guess, by how Mr. Lee recreated the exact image using the text prompt. So there was that image that Mr. Lee was imagining, and he did not stop until he was satisfied that, yes, this is exactly what I had in mind, and thereby, court was satisfied. That is the essence of the creative process, and therefore copyright can attach. And in that basis, the court ruled in Mr. Lee and granted him the copyright. Okay, right. So, other legal and ethical considerations. Well, right now, copyright is still well, you have those two schools of thought, and there are other legal battles concerning AI. Sorry. Like, take this for example. I think you're aware of a bunch of litigations against Microsoft, OpenAI, Stability Diffusion, Midjourney, across various jurisdictions concerning training data. So, copyright has been touted as a potential threat to AI actually because, as pointed out by Professor Jurello earlier, the efficacy of AI depends on the training data. The less training data AI has, the more useless it is. Okay, you have that pug problem that he pointed out earlier. So the reason why AI is so effective is because it was able to get a lot of data, and it is the rights to the data that was fed to AI that is now the battleground. Did the AI operators infringe the rights of the owners of the training data, which is a collective? So here, you have a case of New York Times and Authors Guild. So Mr. Grisham and George R.R. Martin are part of this case. This is a consolidated proceeding, 4 cases before the New York District Court, all accusing Microsoft, ChatGPT, that the training data that ChatGPT was trained with was an infringement of their rights. Okay. Interesting also is this case, because here, before the part of the evidence the author submitted in court was an admission by the AI system. He asked OpenAI, is my book part of your training data? And the AI said, yes, Julian Sancton's book at Madhouse Beginning of Earth is included in my training data. So let's see if ChatGPT's extrajudicial confession can be taken against it. This one has made some progress. So I included this. This is one of the earlier cases filed against OpenAI. This is Paul Tremblay et al. I'm using Sarah Silverman. She's the celebrity who's part of, and she's acting as an activist in this case. So they have various books were also used as training data by ChatGPT, and they have various causes of action: copyright infringement, vicarious, as well as unfair competition, and even negligence and unjust enrichment. And OpenAI moved to dismiss the claims. Essentially, the case was dismissed. So, but I think it was more of because the allegations of the complaint had some deficiencies that were vulnerable to a motion to dismiss. So, in essence, and because for lack of time, all of the claims 2 to 6, the vicarious all the way to unjust enrichment were all dismissed, primarily for lack of allegation as to how the AI system allegedly took the AI, the copyrighted work and used it for its own. But the plaintiffs were given leave to refile if they so wish. Now, I gloss over this because I want to move on. Well, this one is another case, Getty Images, because Stability AI, this was mentioned earlier, it was caught creating work product that had blurred images of Getty's watermark, which again is an extrajudicial admission that part of its training data contained copyrighted material. So this case is relatively early, but this demonstrates that AI is facing challenges across multiple jurisdictions. This is a proceeding in the UK, and they survived the motion to dismiss, and Getty is also filing a proceeding in the US, which is also presently pending. But I want to focus on this case, which is very interesting, because this does not, it has some hallmarks of a copyright proceeding, but the cause of action is not actually copyright, but rather privacy and human identity. So, well, apparently this guy is a mini celebrity. He's like a participant in an American version of Pinoy Big Brother. So they have this show called, Big Brother, yeah. So he's Kylan Young. So he was part of the cast. And when you are part of a show, you execute a contract with the producers. And usually there is a clause there that you assign rights to the show, including your likeness and everything, which is part of the show because you're there, right? So contractually, you already parted to consent to the use of the footages from the show, which includes this, okay? And then for some reason or another, those images found their way to NeoCortex, which is the developer of this app called Reface. So this app essentially allows you to take somebody's image and then create a deepfake. You swap your image, your face, it becomes Mr. Young's face. So his claim is that it's not really because that his face is being used, but rather his body is being used by the app. So he filed an action for damages and an injunction to prevent Reface from continuing using his likeness. This case is also pending trial. But interestingly, the court here, the NeoCortex tried to claim that their app had First Amendment protections, which were, for lack of time, I will just say that the court made short shrift of. But in the materials, you can refer them to them later. Okay. So there is this one too I'd like to highlight. So it's this, I'd like to, gusto ko itong ibangga sa shinare ni Professor Jello earlier about the Philippine Supreme Court. In the US Supreme Court, in Chief Justice Roberts' year-end report, AI was a very big part of his report. It was just a 13-page document, but 6 pages of it was devoted to AI. So I've summarized some of his key points here. So this is, he raised the issue of AI as hallucination. Professor Jello mentioned that earlier, that case involving the 2 lawyers were cited in contempt because they misrepresented 6 rulings as though they were actual rulings. And then you have potential compromise or breach of confidentiality or legal privilege by sharing sensitive information to AI. Okay, so yeah, it's interesting that you can make pleadings using AI, but is it ethical for you to share your client's deepest secrets and ask AI to process it and make a complaint? Because when you type something in ChatGPT's prompt, you're sending it to ChatGPT servers, and whoever's behind ChatGPT knows that data already. So something to think about. Potential bias in criminal cases, flight risk, recidivism, which involves sensitive factors such as race. Professor Jello mentioned that earlier as well. And then this one I'd like to highlight, the human AI fairness gap. We always say that there's always a human touch to the law. And this is a good point by, none less than Chief Justice Roberts. AI takes away the human element, especially in criminal justice. Because if you're going to have an automated judge, then maybe a lot of us will, be guilty of traffic violations, maybe some petty offenses, okay? But there is a human element to justice. So is the need to be very efficient about it a justification to do away with that human element? Time will tell. And then the incapability of AI to distinguish nuances. So, like in criminal justice, witness credibility and demeanor. Do you think AI can detect insincerity or fear? Well, there is a field of study showing that AI can detect subtle facial cues. So there is that bit of technology. But as to whether it can, in the setting of a trial, determine credibility is another thing altogether. But something worth thinking about. And then in gray areas, like in certiorari, somebody says grave abuse of discretion. The data set of AI has a bunch of, other texts as well. Can the AI make a ruling just because it thinks there's more cases where grave abuse of discretion was denied, and therefore it's thinking that this thing is likely 75% similar to the rest of the cases where grave abuse of discretion was denied, therefore i-deny ko to. But then again, it might have been the appropriate case where grave abuse of discretion was in fact committed and you need that certiorari, or maybe you need that writ of amparo or writ of habeas corpus. Okay, so that's a problem as well. Okay, and then finally, AI is dependent on existing information. This is a very nice point that he said. It cannot create anything new. Humans do that. Okay, so do we want to take that away from the law? Maybe not. Okay, so this is the Mata versus Avianca case, the one involving Schwartz and Loduca. They were sanctioned by the court for using fake cases from ChatGPT. This one is also another one involving AI. So you have here this guy. He's from the group Fuji's, Pras Mitchell. I don't know who he is, but some of the young ones might know who he is. But anyway, apparently he's facing a white-collar charge for money laundering, witness tampering, campaign finance, an impressive criminal resume, at least. But he was convicted of these charges. So, but these charges were not the reason why this is in this presentation. The reason why his case is in this presentation is because his lawyer used AI to draft the closing arguments addressed to the jury. And it appears that the lawyer who used AI had a financial interest in the AI system that he used, and that apparently he was planning on, when he won the case for Mitchell, making a press conference that he used AI in the first successful criminal defense where AI was used. But unfortunately, Mr. Mitchell was convicted, and now in his appeal, the new lawyers of Mr. Mitchell are saying that the old lawyer was negligent and acted but unethically when he used AI for his closing argument. So it's grounds for a motion for a new trial. At present, I think its motion is also pending. So I'm keeping an eye on this case because if it's granted, well, that's something to think about. So some closing thoughts. Sorry, I wanted to give more answers, but I think I'm just raising more questions. Does this mean that the legal profession is screwed, we're obsolete, we're going to get replaced by robots? Of course not, because as pointed out by Chief Justice Roberts, there's a lot of aspects that cannot be replicated with AI. But are there important things that we can get from AI? Yes, because they're a big help for the creative industry. But as to whether the products of AI will enjoy the protection of copyright, well, I will wait for the official directive of the Intellectual Property Office on that, because I believe they issued a press release last year where they were guided by the U.S. Copyright Office, but they've yet to formally issue a directive. And the reason why I'm waiting is also because I heard a lecture given by one of the lawyers of the Bureau of Copyright discussing the same Chinese case that I discussed earlier. So I'm sure they're on a wait-and-see mode, or they will come up with a guidance for our creatives in the Philippines. Because I think our creative industry would benefit if they can use AI tools reliably, because they know that they don't have any risks, and at the same time, they can claim ownership over the work product, which is what one of the goals of copyright law. Okay. So just some more questions to end this presentation, but I think I'd rather leave it there, and I think everyone would rather ask questions of us, so I open the floor to questions. Thank you very much for your kind attention, everyone.
All right, thank you, Attorney Angeles, for sharing your expertise to us. Now we come to the interactive part of this afternoon's forum. We open the floor for questions. Please raise your hand and a microphone, or go to the microphone podium, microphone stand near you, and please identify yourself and your affiliation, the organization you're with, before you ask your question. Okay? Anyone? Yes, sir.
Yeah. Good afternoon, everyone. Dennis Manalo from the Dennis Manalo Law Office. Question to Attorney Angeles. Has there been any attempt to have a local copyright of an AI-generated work in the Philippines? Anything from the IPO office that you've heard? Because you've explained the American policy and the Chinese policy, so my question now, is there a Philippine policy?
Thank you, Attorney Manalo, for that question. Yes, I think I'm trying to recall if they published a decision on. I remember there was one, but and it was not granted. But because I'm not sure, I hesitate to say yes. But I do remember that press release that they said, citing the Copyright Office guidance, which is why I make a reference to that here. But it's not an official it's not an official policy yet of the Intellectual Property Office. So that's why I'm waiting for their rules, because right now they are promulgating new rules. So they just came out with rules on geographical indications, new rules on trademarks. And my guess is that copyright would come next. So it's hard to rush ahead, but yes, but it has to, the decision point will come sooner than later, and I think they are aware of that. So as to whether or not there is there's been application that's been denied, anyway, I think there is, but I'm not too sure. I'm sorry.
Okay. Next question, please. Anyone? Yes.
Good afternoon, gentlemen. I am John Michael Tipon from Tipon Law Office. My question to both speakers is, how do you explain, if any, that artificial intelligence is the cornerstone of what's the policy of Marcos administration with respect to artificial intelligence, and how it can be an effective and efficient government if this present administration is going to implement artificial intelligence?
Okay, thank you for the question. I think we could take guidance from the latest SONA. Surprisingly, AI was mentioned. But from what I heard, it's mostly TVET. So TVET magkakaroon supposedly ng AI training, and parang ganun, mostly training. So we're at this point that the president is pushing for digitalization, no? And for me, that's a prerequisite before we head over to AI, because without the digital data, we cannot train the AI. So for me, we're in a good space, no? Pinupush ng president yung digitalization, but at the same time, nagko-coincide si age of AI. Now, as regards the question on how can we use AI for effective governance, actually, as I said kanina, limitless. We just have to be creative about it. When we say AI, pag inisip lang natin ChatGPT, we are already boxing the limitation. So for example, AI for freedom of information, no? One of the projects, so I took my master's, and one of my master's requirements is a capstone project. So one of my classmates, what they did was to implement AI solutions for freedom of information. Normally, when we do freedom of information, mag-shotgun lang tayo. I want information on prisoners, for example. Tapos, i-shotgun na lahat, Bucor, BJMP, even remotely relevant government agencies. No? But what my classmates did, for example, was, okay, we have this query here. Now, can we recommend the top 3 agencies that the question should be forwarded to? So, I think it's a matter of identifying the areas where there are pain points and connecting to AI technicians na, okay, we have this pain point here now. How can we use AI for this? Because I also see certain use cases. So right now I'm being consulted on one, and ang tanong sa akin is, can we use AI for this? Now, simpleng mapping, for example, ng nitong database ito with another database. So my question is, do we need AI for this? So sometimes we already think about AI as the panacea or something that has to be done. But from a technical and practical perspective, maybe AI is not yet the solution. Now, it could be one of the solutions, but implementing AI per se would take a lot of human resources, computing power. Baka naman ang solution is simpler. So to answer the question on how do we have better governance is, I think as people, as the sovereign people, and even among the government agencies, we should have a certain level of self-awareness na, okay, nasaan ang mga funnel, nasaan ang problema. And then, in addition to identifying the problems, we should have that acceptance na, okay, we need help, maybe, no? Na maybe technology can help us here. Kasi sometimes mahirap yung silos. The silos present that roadblock to innovation. So paano ka mag-AI kung even ultimo digitalization, no? Ultimo ayaw mag-usap ng certain offices. So yun, we have a lot of things to work on, but I think we are going the right direction by pushing for that digitalization.
Thank you, Jello. With respect to governance, I think for one, you can look at the COMELEX initiative, for example. So they're thinking of leveraging artificial intelligence, not just not just to protect the electorate from its risks, but using information that they can glean from data. So one use case of artificial intelligence, you can get analytics from it. You can get insights from it. In other jurisdictions, they use AI for biometrics and recognition can be used as an accurate verifier of personal identity. So we have a problem with, for example, fly voters because we have that indelible ink, right? So maybe use biometric registration systems to make sure that this person, isang beses ka lang pwede bumoto, for example. Another aspect would be cybersecurity. So I think we know that there have been a lot of cyber attacks, both in the private and government sectors. And these cyber attacks have caused, well, some nominal damages, but some a large amount of damages as well. It's also, so AI can also be deployed as a protective mechanism to keep our assets, our critical infrastructure safe from harmful threats. So just a few examples. I think also on the effective data gathering. On the data verification aspect earlier. I remember there's this issue about the birth certificates being falsified, and that's a big problem. So biometrics can play a key aspect to that. So there's a lot of use cases, and I think that's why it's good to start from top to bottom. So there's a broad mandate, and our respective line agencies are given, at least you can identify what your priority areas are as well, because you have a clear direction from the chief executive.
Add lang ako. So thank you, for that. I am also reminded one of the requirements in my class naman, so I teach AI and law to law students, is to create AI-powered legal solutions. And they went over and beyond chatbots, ChatGPT. There was one project, for example, was verifying candidates for local elections. So imagine COMELEC website, fill out ka lang ng certificate of candidacy, and then the AI there, so may interview ka with the AI, ganon, and the AI can tell you na, oops, mukhang nag-travel ka based on BI records, immigration records. Looks like you traveled using an American passport. Can you explain that? So that presupposes, again, being aware of the issue. So actually, itong project na to, bunga nung recent issue, in one of the mayors na allegedly ni Filipino. So ayan, it takes a lot. It takes having ears open. Ano ba yung issues? May issues ba ngayon? How can we go beyond chatbots? How can we go beyond ChatGPT? And how can we make, everything better sana? So na-impress ako gawa ng estudyante. So baka tayo, since we're practitioners also, meron din tayong sariling pain points na pwedeng masolusyonan. So we could start with our own hugots, and then tingnan natin, can AI be used here or pwede bang ibang solution?
Anyone else who would like to ask? Yes, sir.
Good afternoon again. To Professor Santiago, earlier I recall that you mentioned that you attempted to ask AI if a certain product is AI generated or not, and the response was a certain percentage, I understand. Now, my question here comes from the point of view of pinpointing liability in the event that AI has been used to damage someone or to cause injury to someone. Is there a way that we can pinpoint liability towards a warm-bodied individual? Like the nearest analogy that I can think of is like a ballistic test for a gun. You can pinpoint the actual gun that was used to kill a person. Can you actually pinpoint, can you actually trace somehow where an injurious AI-generated product came from? Sorry, because I'm not really that much of a techie, so
All right.
I wouldn't really know if there is such a process.
All right, thank you. For example, let me start with an example, correct? ChatGPT. If you use ChatGPT, all your chats are stored there. So you can revisit all of your previous chats with ChatGPT. So in a way, because it's recorded there, pwede mo nang makita doon na, okay, this was generated by ChatGPT. But as regards ascribing liability, it's kind of a murky area pa. Kasi when we use AI, likely there will be terms and conditions of use. Like when we use Facebook, may terms of service. So kung ako si ChatGPT, I will wash my hands on whatever liability. Parang caveat lector or caveat user, no? Pero we could maybe look at, for example, product liability laws. So yun yung nabanggit ko kanina na if we're looking at AI as a product, then we could sue the company maybe because there might be some warranties na hindi nami-meet. So merchantability or some other warranty that provided by law. So we could ascribe somewhat, pero as regards sino yung mananagot kung gusto mo ng kulong, baka mahirap. So baka civil. All right.
Thank you, Professor Jello. Actually, in relation to what he said, product liability laws, that's the end route. So that will be your cause of action against the manufacturer or the operator. And then you can use cybercrime against the actual perpetrator. So, Attorney Dennis, that's a good question because in other jurisdictions, one data governance or one AI governance model that they're trying to employ is requiring work product of AI to have, well, for lack of labels, digital fingerprint or metadata embedded into it. So they're using that for deepfakes. So, for example, if I think there's was it Brazil who required it? I think Brazil, the Federal Electoral Tribunal over there came up with a bunch of regulations, among which they required that if a candidate or political party is going to use AI, they must disclose the fact that they are using AI. And I think there is a requirement there that it must bear their signature, kumbaga. So it's traceable to them. So there's accountability. So that's how AI governance can be a game changer. You set the rules for people using it. Yes, you can do this, but you have to do this properly. Because for traditional crimes, we can identify the perpetrator with the proverbial smoking gun or the fingerprints in the gun. So you can apply that logic to AI, give a digital fingerprint to the output that is traceable to somebody that we can hold accountable. A political party, a candidate, maybe a company who's giving advertisements, or if it's general use AI, at least attributable to a user profile which uses that account. Now, the problem with ChatGPT is that it's free to use, and sometimes people can use it without an account or personal identifier. So there's a challenge there. So in a way, the AI Act model of the EU is interesting because when they have a register, and for high-risk AI, you will be able to monitor who's using it, because part of the requirements can be they will need to be able to identify who's using their model, and because of the post-market monitoring mechanisms that they have in place, trace back if somebody lets loose something that is harmful, then there is some measure. There's a paper trail of digital paper trail of accountability, so to speak.
Thanks. Quick add lang, no? There are moves from the industry. For example, si Facebook, Meta, rather. If you use generative AI with them, meron siyang watermark, for example. So sila na mismo yung nag-offer na this is AI generated. So in a way, from the industry, they're trying to also, as mentioned, no, proper governance. So they're also the ones offering na ito na po, we don't really want to contribute to misinformation. So here's our part. So yeah.
Okay, I guess one last question. Yes, sir.
Louis Aseoche from Travis Miranda Aseoche Law Office. Attorney Angeles, you mentioned about the no gatekeeper liability observed in the US. Does that obtain also in our jurisdiction? And do you think, does that also obtain in our jurisdiction? And do you think, or do you anticipate that that will pose a challenge to establish culpability or authorship of the deepfakes? Can those gatekeepers be compelled to provide fingerprints in order to establish the culprit?
Okay. Thank you. That's a very good question, sir. To my knowledge, we don't have a counterpart for Section 30 under our laws. But the challenge is not the lack of, or not not the presence of liability immunity. It's rather the reach of legal processes to the platforms. So in other jurisdictions, gatekeeper liability is successfully enforced because those jurisdictions have mature extraterritorial processes. So they can serve summons abroad. If you don't show up, they will render a default judgment against you, and we will enforce the judgment against your properties in that jurisdiction, or they can take down your platform if you are not compliant, meaning they can deny access to service. Now, that was taken down. We used to have that, but that was declared unconstitutional in Dicini versus Secretary of Justice under the cybercrime law, because the power to take down was not subject to a court order. So perhaps if we bring that back with appropriate safeguards, then that can address that gap. I hope that addresses the question, sir.
Okay, I think we can accommodate one last question because si Sir kanina, he also raised his hand. So, final question.
Good afternoon. I'm Nestor from Justicia, the University of Makati School of Law Journal. My question is related to creatives. So what is the advice that you could give to creatives that is using AI in order to generate their contents and at the same time make their work copyrightable or secure their work as far as the present lack of regulation is concerned? Thank you.
Thank you. That's a very good question. And given the state of affairs, I remember the guidance by the IPO contained a spectrum or a slider rule that similar to, if you can show that your authorship satisfies the originality, they can be prepared to consider as the work as original. So there was a statement to that effect. So my advice would be, when you apply for copyright with the Copyright Office, so I think this puts a premium now on filing copyright applications with the IPO. Why? Because before, we used to take this for granted because copyright protection became a matter of fact simply by the act of creation. That's under our civil code, actually. And that's in accord with the Berne Convention. But now, with this one, with the time you save from AI, so to speak, you can take the time to create an affidavit of ownership, okay? And there you set forth your creative process for the for the Copyright Office to consider, okay? So that you give a reliable basis for the for the Copyright Office to at least distinguish what are the human elements of this work that are deserving of copyright. Because I think for creatives, they don't need to copyright the entire work. They need to at least be able to show that this is our work. The attribution is the important thing. And I think the harsh part of the US rule is that it denies even the attribution aspect, right? Because they can make the economic they can earn the economic aspect anyway, because they commission the work, somebody will pay for it anyway. They don't need the law to enforce that contract. But at least the right to be able to say that when I become famous for this kind of work, right? They will be able to point that this is, I have been recognized as a copyright owner for these works. And I think that's, there's value to that. And I think this is something that the IPO is taking very seriously. So that's why I'm eagerly awaiting what they're going to say about it. So let's just wait. Because they really are, they're very forward thinking, I believe.
All right, I think that's about all the time that we have for our open forum. Thank you very much for all those questions. Now, to formally close our forum, we will hear from no less than the President of the Philippine Bar Association, Attorney Joey Raymond Aison.
Wow, we have a full house today. First of all, I would like to express our appreciation to our guest speakers, Professor Angelo Ocampo, Attorney Darwin Angeles, and our host, Chris Ocampo. The PBA has a small token of appreciation for you gentlemen. Please stand up. Can I request Trustee Charles to help? This has indeed been a very enriching afternoon for all of us. I have to admit that the AI I knew was a TV reality show which produced the likes of Kelly Clarkson, David Cook, and the like. But we all know today that AI is for artificial intelligence. You may not know it, but in a survey conducted late last year by LexisNexis among lawyers, law offices, and consumers in the US, Canada, UK, and even France, 47% of the respondents agreed that Gen AI will have an impact on the practice of law. 45% agreed that it will have some impact, while only 7% said that it will have no impact on the practice of law. As students of law, we all know that knowledge is power, whether it be in the form of a new regulation or a ruling, or even Marites. So the question is, will AI threaten our knowledge? Will it level the playing field? Or will it even demand further human diligence on AI-generated information? As discussed by our speakers today, AI is essential to lawyers in the discharge of our duties and responsibilities to the best of our abilities. As lawyers, we are expected to know the legal effects of AI, to work for justice and safeguard the rights and meaningful freedoms of all persons, identities, and communities. And as our lawyers, we are expected to think about and be guided by ethical considerations when dealing with AI. It is hoped that today's forum helped increase our level of understanding of AI and the relationship of AI and the legal profession, with the goal of applying today's lessons in our practice of law. And to mimic the Terminator, hasta la vista. Enjoy the rest of the afternoon and have a nice weekend. Thank you.
Thank you very much, President Aison. Before we end, may I ask everyone to please rise for the PBA hymn.
We are the PBA, heirs to a glorious past, kindred and noble purpose, to blaze the future's path. Let us be the shield against lies and oppression. Let us be the light to bring justice home. Through time we have stood constant, faithful to our own, champions of the oppressed, guardians of the truth. Under our watch, let no one be denied. Under our watch, let no one be deprived. Our fight for justice is a fight that we shall wage with fervor and honor to the very
All right, that concludes our program this afternoon. Thank you for joining us and enjoy the rest of the day. Thank you. Just a reminder, please don't forget to sign the attendance forms and to submit your evaluation forms so you may earn your 2 MCLE units.